Good afternoon, everyone. Namaste. I am CA.Priyanka Chordiya, representing CA Sansaar channel. Today, we are going to discuss on Real Estate Regulation and Development Act 2016. So, before we actually start the presentation, we will throw some light on the history of the real estate sector. So, before this act was established, this sector of real estate was not very much organized. The customers or the home buyers were not satisfied because of the delayed possessions, change in the layout plans, and many a times unreasonable interest rate which were charged by the buyers. But after this act came into force, this sector got some rules and regulation laid down, and that is the reason it became easier for the customers or the home buyers to buy new properties in this under this act. So let's see the presentation, and first we will see what is the summary of this session, what we are going to discuss in this next few minutes. So the first thing we would see is objectives of RERA Act. The second thing we would see is when RERA Act came into force. The next one would be applicability of this act. Then it would be exemptions under this act. Then we would also throw some light on rules prior to the registration, which are the prerequisites which are application and registration. Then we would see application. The next would be grant of registrations by the RERA authority. And after that, it would be revocation of registrations by the authority under few circumstances. Then the next would be registration of real estate agent. So basically, this is the summary. We will throw light on all these topics one by one. So the first thing is objectives of the act. So let's talk why this act came into force and what different did the authority they'll be doing in future under this act. So the first thing would be regulation and promotion of the real estate sector. As we discussed before, the situation was not pretty good before this act came into force, but now the rules and regulations are laid down under the central act, which is called as RERA, and also rules and regulations are given by the state authorities differently. Every state has some or the other rules and regulations laid down. The second thing is sale in efficient and transparent manner. As you know, whenever you want to buy something, transparency is very much essential. So this is one of the objectives under the third thing is protecting the interest of the allottees and the consumers. As I said earlier also, that home buyers were not pretty much satisfied with the builders or the schemes or the commercial projects they were getting into. But then, yes, after this act came into force, definitely it is going to protect the interest of the allottee and the consumers. The third thing is growth of real estate sector. Real estate sector has always been booming. And as we know that house property or any commercial property is like a basic need which is needed in everyone. So yes, growth of real estate sector was also one of the objectives under this act. The next one is to establish an adjudicating mechanism for speedy dispute redressal and to establish the appellate tribunal. So before this act, the consumers or the home buyers, they couldn't go and complain to some specific authority for speedy dispute or what trouble caused them in the long run. There was no authority. But now, under this act, they have established a mechanism wherein the complaints are taken and they are solved in really and as in on fast basis. And they have also established an appellate tribunal, which would also be essential in cases where it is not the complaints are not solved by the RERA authority. Then the next thing we would discuss is when RERA Act came into force. So the act was cleared by Parliament in March 2016, and on 1st May 2017, the act came into force. These sections, these 92 sections were notified. So what's the state government role in this process? So it is mandatory for all the states and the union territories to settle disputes. So RERA is always a state subject. The main role under this act is of state government. And so every state has laid down their rules and regulation in line with the central act, which is RERA Act. So till now, 21 states have notified their rules. Then the governing authority. As I said, it is a state matter, and each state will have its own state authority for RERA. The next thing we would throw light on is applicability. So to whom does this act apply? To what kind of property you are buying the act is applicable? We'll just see. So the first thing would be commercial real estate projects. So this includes all kind of shops, all kind of offices you are buying, the showrooms or the godowns. Then residential apartments. So residential apartments include everything, flat, house, whatever you're buying under the project. The third thing would be plotted developments. Plotted developments were assumed that RERA is not applicable in that case by many people, but no, the Act has specifically given plotted developments is included in the projects, and that is why it is all RERA Act is also applicable in this case. The fourth one I would say is ongoing projects to which the completion certificate has not been issued. So the Act became applicable from 1st May 2017. So till that date, if any project has not received its completion certificate, then definitely these all projects need to get registered under RERA Act. Then there is this explanation given which says if your real estate project is built in phases, then each phase needs to be registered separately. The next thing we would see is exemptions under this act. So the first thing is projects being developed on a land less than 500 square meters. So any project, अगर आप कोई प्रोजेक्ट बना रहे हो वो 500 स्क्वायर मीटर्स के नीचे है उसका टोटल लैंड, then definitely you don't need to get registered under this act. The second thing is number of units should not exceed 8. But this includes all the phases. Suppose you have 4 phases, but then the total number of units of all these 4 phases should not exceed 8. If it exceeds 8, then you have to register under this act. The third one is the projects which have already received their completion certificate before the commencement of act, that is 1st May 2017. Then the next is redevelopment real estate projects where no new allotments are to be made. So these need not get registered under this act, the redevelopment real estate projects. Renovation and repairs. This is very similar to what we spoke earlier, that is redevelopment. But then this renovation and repair projects, they should not involve any marketing or advertisement, selling or allotment of any apartment or plot or building. So if you're selling even few flats to the new owners, you need to get registered under this act. Otherwise, there is no need. And this act also excludes the ready to occupy property in the resale market. So the resale market properties are not covered under this act. The next we would see is rules prior the registration, there are these few things we need to keep in mind before you get registered. What things you can do and what things you cannot do before you get registered. So the first thing we would see is no project can be advertised, booked, sold, offered in any form prior to registration and obtaining necessary construction approvals. So basically this point says that you need to registered first, and only then you can promote or sell or offer to sell your project property. The second thing, otherwise there are these penalties which are let down, and they'll get applicable if you do any of these things before registration. The second one is any real estate project more than 500 square meters or more than 8 apartments has to be registered with the regulator. As we discussed in exemptions, that if it is less than these two things, then you don't need to get registered. But then yes, if it is more than 500 square meters and 8 apartments, you need to get registered. The third one we would discuss is projects without completion certificate are now required to be registered within a period of 3 months from the date of commencement of this act. So as we said that the act came into force on 1st May 2017. So within 3 months, you were supposed to get registered. I'm sure all these projects who didn't receive the completion certificate must be registered and completed till date. Each phase of the project to be registered differently as a stand-alone project. So if your project, again, if it is in phases, you need to register all the phases differently as a standalone project. The next we would discuss is application and registration. Application for registration of real estate project is covered under Section 4 of the Act. So every promoter shall make an application to the authority for registration of real estate project in such form and manner within such time and accompanied by such fee. So basically, under Section 4, they have let down that these regulation actually shows the form and manner. So we can definitely have some session wherein in detail we can discuss the form and the manner and the other things which are required. Then the second thing is the authority shall operationalize a web-based online system for submitting applications online for the registration of projects within 1 year from the date of establishment, and which is already done by the authority. The web-based online system is working, and you can register all your, you can submit all your applications online. All the states who have already, who are already following this RERA Act have their online. So you can go and register. The next thing we would discuss is a picture of whether it's granted or it's rejected. If they have not done anything, then it is deemed to be accepted by the RERA authority. Registration is valid for the period of completion of the project. So whenever we apply for registration, we need to put this period of completion of project in that form. So registration is valid for till that date, what we've put in the application. This date may definitely be extended by 1 year, but it is on limited grounds and payment of fees. There are few grounds which are laid down by the RERA authority and the Act. So we can just go and check if we can apply for the extension or no. The next is on registration. Promoter gets a registration number. So whenever your registration is granted by the authority, so the promoter gets a registration number, it gets a login ID, it gets a password to authority website to create his own page and provide project details. So whenever the registration is granted, you need to go and log in to your state's website, and you need to create a own page wherein you need to provide detailed explanation of the projects. For example, like where it is located, how many units are there in every building or every phase. So likewise, it is a detailed explanation which needs to be given on that page. And also you need to put in the real estate agents which are registered under your project. And so Likewise, people can go and also contact the agents, and then through that they can buy the property under your project. So the next thing we would see is revocation of registration. So revocation is done by the authority in few cases. Okay, so registration may be revoked on a complaint suo motu if. So the first thing is if promoter defaults under the Act, rules and regulation. Under this Act, there are lots of duties and rules which need to be followed by the promoter. So any of the let down rules and duties, if they are not performed by the promoter, then definitely the registration can be revoked. But then there needs to be a complaint by the consumer or the home buyer. The second thing would be if the promoter violates the terms of the approval for the project. So there are these terms and conditions which are laid down whenever you make the application and registration under the project. So none of be violated by the promoter. Otherwise, he needs to face the revocation. The third thing is involved in unfair and irregular practices. So fair and regular practices is a must when it comes to building up a project and selling and all the things which you are conducting under this project of yours. So if you are involved in unfair and irregular practices, then definitely you need to face revocation. Then we would discuss is the promoter, if the promoter indulges in any fraudulent activities. So fraudulent practices are complete no-no. Otherwise, you definitely need to face the revocation by the authority. The registration granted to the promoter under Section 5 shall not be revoked unless the authority has given to the promoter a notice. So basically, the authority cannot just revoke any registration. They need to give a 30 days prior notice to the promoter stating the grounds on which it is proposed to revoke the registration. So after considering the notice, the things which are provided by the promoter, uh, the authority will check if there is a default or no, and accordingly they will propose the revocation, or maybe they can just cancel the revocation. So next we would see is registration of real estate agent. This is the last topic which we would be discussing as we saw in the summary. So real estate agent, they play a very important role when it comes to buying and selling of properties. Because many a times we fail to directly go and reach promoter and buy or sell a property. So these real estate agents are the helping hands. They are the mediators, the facilitators in such kind of transactions. So a real estate agent need to get registered under this act. It's mandatory. There is no other option for this. Otherwise, again, the real estate agent or the project need to face the penalties. So no real estate agent shall facilitate the sale or purchase of or act on behalf of any person to facilitate the sale or purchase of any plot, apartment or building. So if there is real estate agent involved, he needs to be registered for any kind of activity you're doing, like sale, purchase of any plot or apartment or building in any kind of real estate project. Okay, so all this is registered under Section 3 and being sold by the promoter in any planning area without registration under this section. The second thing is the authority shall, within such period, in such manner, and accompanied fees. So basically, after the application by the real estate agent and after paying the needed fees, the authority shall decide that the real be given a registration or no. So basically, if they are granting a registration, so it would be a single registration to the state agent for the entire union authority. So basically, if the registration does not conform to the provisions of the Act. So basically, before getting registered and before applying, we should have a fair idea of the prerequisites of application and registration. So yes, these were the things we threw light on today. So if anything else needed, we would definitely discuss that in some next video. So everybody, thank you so much. Thank you CA Sansaar channel. Thank you Vivek sir and the team for the opportunity you've given me. Thank you so much.